Now, to speak to the CV of Professor Halton Cheadle in itself will take the time of this particular webinar. Safe to say that Professor Cheadle is the founding director and still associated with Cheadle, Thompson and Haysom, one of the leading law firms in South Africa since its start up until now, still actively taking forward the case of trade unions as one of its key constituent members. And Halton has been a part of that from the start. He's also an emeritus professor from the University of Cape Town, specializing in labor law, public administration law, and the many other ventures that Halton has contributed as part of the labor law jurisprudence in South Africa. Professor Cheadle published extensively on labor law. I was fortunate enough to co-author with Professor Cheadle on strikes and the law. Incidentally, the subject matter of this particular webinar today, aside from his extensive academic publications, he was also the convener of the Labor Relations Act, as well as many other pieces of labor and other law in South Africa. He also co-drafted the Bill of Rights that many students and others rely on in making an argument for the existence of a constitutional right. So you have Professor Halton Cheadle to thank for much of that. So without further ado, I will hand over to Professor Halton Cheadle that will introduce Convention 87. I should add that Professor Cheadle was also the person who argued the matter before the International Court of Justice in The Hague, arguing the matter on behalf of the South African government. And those proceedings were conducted in 2025. And I'm sure that if it had not been for the level of argument presented by Professor Cheadle, we may not have had the outcome that we are currently able to celebrate. After Professor Cheadle's input, I will then introduce another international icon in the trade union movement, Christina Olivier. Halton, I'm handing over to you.
Thank you very much, Mario, for those very kind words. Mario, you said that you would be able to just quickly share Convention 87, just so that, because it really sets the context of the ICJ's decision and why it is such an important decision.
Leonor Schuller, our academic administrator, kindly agreed to do so, which can be seen now.
Fantastic. If we could just move down the screen, I just want to highlight certain words. So this is Convention 87 on freedom of association. And if you have a look at the fourth paragraph in the preamble, considering that the preamble to the Constitution of the International Labour Organization declares the recognition of the principle of freedom of association to be, this is very important wording for the ICJ and the South African government's argument, as a means, I want to underline the word means, of improving conditions of labor and of establishing peace. And then in the next paragraph in the preamble, you'll see there's reference to the principle of freedom of association forming the basis for international, essential to sustained progress. Essential to to sustain progress, also language that the ICJ relies on. And then if we now go into the body of the convention, just go further down and we'll see if we move to Article 3. Article 3 now is the critical article that is being interpreted. It reads, as you can see, workers and employer organizations shall have the right to draw up their constitution and rules, to elect their representatives in full freedom, to organize their administration and activities, and to formulate their programs. So the important language there is to organize their administration and activities and to formulate their programs. And if we look at Article 3.2, the public authority shall refrain from any interference which would restrict this right or impede the lawful exercise of it. So the word lawful is very, very important language, that these rights to organize have to be lawfully exercised. We can go down further down now to Article 8, I think it is. And this is important language in exercising the rights. That's the right to organize that we're referring to. Workers and employers organizations and their respective organizations shall respect the law of the land. Shall respect the law of the land. And then subarticle 2 says, but the law of the land shall not be such as to impair the guarantees provided in this constitution. And really what we argued was that it's quite clear that these activities are regulated activities. They have to be lawful and they have to be given effect by law. So that's really the convention. That's the wording of the convention. That's really the subject of the decision. Now, the employers took the view that if we could go back to Article 3, if we may, they took the view that actually all that Article 3 protects is the internal organization of the trade union. In other words, that during the fascist and Nazi regimes, bearing in mind this comes after the Second World War, is that they banned these organizations. They never gave them the right to establish their own constitution and rules. And that really the activities and programs here all really related to the internal organization of unions, and therefore did not include external activities, such as collective bargaining or strikes or petitions to government and the like. So, and that is, I mean, the employers had various arguments and some governments also had various arguments. And the most important argument that they raised throughout is it doesn't mention strikes. It just mentions activities. And so that's the nub of the dispute. Now, historically, in order to understand how this particular convention has been interpreted, we've got to understand that there are two supervisory bodies in the ILO. The one is the Committee for Freedom of Association, and the other, established in 1951. And then there's the Committee of Experts on the Application of Conventions and Recommendations. That was established in 1926. So these are the two supervisory bodies that supervise compliance with conventions. Now, the Committee on Freedom of Association is a complaints-based body. So a government, an employers' organization, a workers' organization can refer a complaint against the government, and then the Committee on Freedom of Association then gets information, collects evidence, and makes a ruling and decision. And it's restricted purely to freedom of association, complaints concerning freedom of association. There are other supervisory mechanisms for other areas of the ILO, but that's complaint-based. But this one is specifically related to freedom of association. And over the years, since their establishment in 1951, it has, made decisions that banning unions, banning trade union meetings arising out of strikes, banning of strikes, and illegitimate limitations on the right to strike. So really, since 1951, it has developed a jurisprudence around the right to strike, very much following what the other supervisory body does, which is the Committee of Experts. Now, that jurisprudence one will find in digests. So there's a digest of decisions of the Committee on Freedom of Association. And if you take the booklet today, you'll see that many pages are determined. So complaints come in, they make a decision in line with the previous decisions, and slowly but surely a jurisprudence is developed. And it's a point that was made to the ICJ, was that in fact these supervisory bodies operate very much like a common law system. In other words, once the jurisprudence only develops once you've got a complaint, and then you apply the rule to the complaint, and then you create subsidiary rules, and slowly but surely that's what happens, and that's the explanation as to why they didn't assert a full right to strike in respect of everything right from the very beginning. And by the way, that's one of the critiques in the dissenting judgments. One of the critiques is that they never interpreted the treaty in the way that they're now treating it and interpreting it at the time. So that's the Committee of Freedom of Association. The Committee of Experts, as late as by 1959, had started to pick up in government reports that it looked at that certain governments' legislation was too restrictive of the right to strike, and so it too would make observations to governments, engage in the dialogue with governments, and whenever there was a general survey on freedom of association, it would collect all those decisions, and it would become part of what is called the general survey. And if you now go to the latest general survey on freedom of association, you'll see that 20 or 30 pages addresses the issue of the right to strike. So both bodies have understood that the right to strike emanates from Article 3 and falls under that term activities and the term programs. So these are all programmatic, they're activities, and accordingly the wording is sufficiently wide to include the right to strike. And then of course what they are looking at is whether or not a government in sub-Article 2 that you have in front of you, are they restricting or impeding the lawful exercise of that right? And if the essential services to strictly defined or to widely defined, they will say no, this is you're impeding the lawful exercise of the right to strike. And that's how over 50 years you have a development of the rules relating to essential services. The same thing applies to secondary strikes and the like. So by the turn of the century, it was pretty fixed that Convention 87 included the right to strike, certainly insofar as the two supervisory bodies were concerned. Up until then, there were odd objections by countries over the period, governments who said, no, it doesn't include the right to strike. But in the 1990s, there was the beginnings of sustained attack by the International Employers Organization, Organization of Employers, arguing that, in fact, that there was no right to strike included in Convention 87. And by 2010, this had turned out into a full crisis, and they refused to deal with any matter which involved the Committee of Experts' decisions relating to the right to strike. There were various attempts from 2010 onwards to try and find a solution, but finally, no solution was found, and the general, the governing body referred the right to strike to the International Court of Justice, which under Article 37 of the ILO Constitution provides that that's where these disputes of interpretation go to in relation to conventions or the Constitution itself. And that really is the background to the to how the matter got there. Once there, governments were asked to submit statements. The South African government submitted a statement, and then governments were permitted to respond to other government statements and employer organization statements. And the South African government did that too. In particular, a body called Business Africa that argued strongly that there should be no right to strike, and that in African countries there was no general agreement on the right to strike. And we were able to show, and that's reflected in the judgment itself, just how extensive governments in Africa have accepted the right to strike as an element of freedom of association. So that's I think the background. Mario, do you want me now to go into the judgment itself?
Yes, please, Halton. Thank you. So,
in order to interpret a treaty, you have to look at what is the Vienna Convention on the law of treaties. Very briefly, that's what the court has used and uses. And really, there are two articles. The one is Article 31 and Article 32, which is the supplementary bases. And so, just to read very briefly. 31, paragraph 1 says, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. So it's the ordinary meaning in its context and in the light of its object and purpose. Yeah, and that's the principal provision. That's the first one that one has to look at. And I'm just trying to quickly find here. And what the court does, and I'm just going to paraphrase, it starts by saying the court observes that strike action is not explicitly excluded from 87. It's not mentioned, but it's not explicitly excluded. And then it talks about the employers and their respective employer organizations, like other persons or organized collectivities, shall respect the law of the land. And they go on to say, these provisions show that workers, employers, and the respective organizations must respect domestic law when exercising rights provided for in the convention. Okay. These provisions, however, do not limit the scope of the rights protected in the Constitution. And in the context of their light and object, the right to strike is not excluded. It then says the absence of an express treaty provision governing a certain issue does not necessarily mean that the issue is excluded, which is what I've just worked through. And then it says that when one looks at the terms workers' organizations and their activities and formulated programs, it says this includes not only the internal negotiation and adoption of constitutions and rules and election of representatives, but also the broader powers enabling workers and organizations to decide on matters relating to the administration, as well as to activities to be performed and programs to be formulated, implemented in both internal and external context. Let me say, it's with some pleasure that one reads that language, because South African government was the only submission which made this distinction between internal activities and external activities, and that to protect only the internal activities of the union without protecting the external activities of the union would simply mean that the governments could ban all external activities, but permit a union to establish its organization, adopt its constitution, and organize, relations with its members. And so it's when I think this is what comes through quite clearly. And then it finally says that reading these provisions in good faith in accordance with their ordinary meaning suggests that under Convention 87, workers and employers have the right to create organizations for the purpose of defending their respective interests, which includes their activities and programs. And then the term strike generally means an activity consisting of a temporary work stoppage, willfully effected with a view to enforcing or resisting demands or supporting grievances. And really interesting is it quotes the Committee on Freedom of Association for that. And then accordingly, a strike falls in the ordinary meaning of activities and programs. It then goes to look at subsequent practice, and which is a supplementary term of interpretation, and it finds that there's a great overlap between other international conventions and ICPR, the ICR, and the court concludes from looking at all of these organizations that have, all these governments that have signed up to all these various treaties. The court concludes the fact that a significant majority of state parties consider that the convention protects the right to strike, and confirms its conclusion already reached under 31, that it includes the right to strike. It's particularly important, I think, is, so that's really the argument around the right to strike. Its ordinary meaning within its context and its purpose, and then subsequent practice, the manner in which governments throughout have signed up to other conventions, both regional and international, that include the right to strike as integral to freedom of association. But what it goes on to do is to deal with the pronouncement of ILO supervisory bodies. So when I was on that committee from 2003 and 2018, we were constantly under attack by the employers, the IOE, that we had no interpretive function at all. And we had to agree to a wording in the general survey that our interpretations were not binding. But what the ICJ does, and I think this is of enormous importance to both the supervisory bodies, it says the supervisory bodies of the ILO differ from the expert treaty bodies with which the court has previously dealt, owing to their specific characteristics. However, the fact remains that both perform a similar function, namely monitoring the proper implementation of the provisions of the convention under their supervision. Consequently, the court considers that it may, mutatis mutandis, ascribe great weight to the pronouncements of ILO supervisory bodies as a supplementary means of interpretation of Convention 87. The court, nevertheless, deems it important to recall that it is in no way obliged in the exercise of its judicial functions to model its own interpretation on that of those bodies, and it cites in a whole range of previous cases. The court has carefully examined the pronouncement of the supervisory bodies that monitor the application of Convention 87 in paragraphs above, and found that those bodies have progressively converged in recognizing the right to strike as protected under the Convention. The court observes that these pronouncements, which constitute a relevant supplementary means of interpretation under Article 32 of the Vienna Convention, confirm the finding reached by the court on the basis of Article 31, namely that article dealing with the ordinary meaning in its context and its object and purpose. There were 4 dissenting decisions, and 3 are in English and 1's in French. But they all take they look at and they're critical of the methodology adopted by the majority, but basically argue that the position of the employers, that, if you take the historical context and everything else, what was really sought to be protected was purely the internal functioning and the existence of unions and their internal functioning, and not their activities. Mario, that I think is my contribution so far.
Halton, thank you for a very comprehensive contribution on the convention itself and how the ICJ got to decide on the matter. I've noted that Professor Paul Benjamin has now joined us, so I need to make the point before I am in trouble with him to indicate that Halton was also the first South African who sat on the Committee of Experts on Conventions and Recommendations. So Paul, hopefully I will not be in trouble with you. Before I get into trouble with Professor Debbie Collier, I should advise you that part of the webinars also for the purposes of academic contribution and to make these recordings available to our students. The webinars are for that reason recorded, and we certainly trust that all of you being part of this particular webinar, you have no objection to the recording itself. I've noted, before I introduce Christina Olivier, I've noted a number of individuals, the General Secretary of the Southern African Clothing and Textile Workers Union, Comrade Bonnie, who alongside the likes of Comrade Christina were, as I would call it, young comrades in the trade union movement who progressed up to the highest levels of union organization in terms of positions held. Comrade Bonnie is the first woman General Secretary of the Southern African Clothing and Textile Workers Union, who also happens to be an IndustriALL affiliate. There's the former ILO director for South Africa, senior members of the Department of Employment and Labor, senior academics, and many others who I've not mentioned others by name, but we certainly have a high profile of individuals attending this particular webinar, and I am most certain that that is simply due because of Emeritus Professor Halton Cheadle and Comrade Christina Olivier, who hails from Atlantis in the Western Cape. We were both young when we were elected as shop stewards. The funny part is that some of us grew older. Comrade Christina, as you can see, still looks as young as she looked then. She got elected as a NUMSA regional chairperson at the time. Also became, I think, a COSATU regional office bearer. There is now provincial office bearers. Comrade Christina got elected initially as the NUMSA second deputy president, then became the NUMSA first deputy president. During that time, she also attended a number of what was then ICAM, IMF, which is the International Metal Workers Fund, not the International Monetary Fund, global meetings. She became the NUMSA International Officer, and then at the third International Conference of IndustriALL, got elected as the IndustriALL Assistant General Secretary. That was in 2021, and got re-elected into that position in 2025 in Australia, if I'm not mistaken. Comrade Christina, it's nice seeing you again. Speaking from Geneva, we have all internationals. The Halton is speaking from the UK, Christina is speaking from Geneva. Speak to us. What does the ICJ advisory opinion mean for global union federations like IndustriALL?
Thank you, Mario, and thank you for that introduction. Good afternoon, everyone. It's very hot where I am right now, but I will try not to collapse under this heat. It's still 34 degrees, so we're struggling a little bit. Firstly, I need to thank Halton for taking us through the legal issues and explanation, giving us a legal explanation in terms of Convention 87. I also want to take a step back to also explain where we are coming from, and I might repeat some of the issues that Halton has referred to. I think it's important to say that for more than a decade, global unions, including IndustriALL and ITUC, have been defending the right to strike within the ILO. And since 2012, employer representatives have challenged this long-standing view that Convention 87 protects the right to strike. And this lead to years of deadlocks where the systems of the ILO could not properly function. I can say that it weakened part of the ILO's work and, like I said, created prolonged deadlocks. This deadlock or challenge continues for some time until 2023, when the governing body took a resolution to refer this matter to the International Court of Justice to provide us with an opinion. And I think for us, the opinion comes at a right time. It's a major step forward for us, not only for IndustriALL, but for trade union movements around the world. And we are really happy that the court has now clarified that the right to strike is indeed a fundamental element of freedom of association. And why this is so important for us, like I said, for many years, there has been disagreements between workers and employers over whether the right to strike is protected under Convention 87. And really what the court has done now is really important for us. It has confirmed what the ILO expert has been saying for a very, very long time. that the right to strike is indeed an element of Convention 87. For us, this opinion has somehow restored the confidence in the ILO supervisory systems after many years of disputes and many years of struggling and many years of making stifling or hampering the work of the ILO. The resistance of the employers and this opinion not only assist us or provide clarity, but it also now provide a stronger legal foundation for us as trade unions, and it could help trade unions in terms of defending their rights through strikes, because being able to strike is one of the tools or one of the weapons that workers have to push back on to push back employers. I think this might also, Mario, allow us to move forward with the work of the Committee of on Application of Standards, because this committee since 2012 largely avoided dealing with strike-related issues because of the disagreement. And we believe that the opinion might unblock the situation that this committee find itself in. Another key point for us is the fact that the court recognizes the role of strikes. It acknowledges that strikes is one of the fundamental tools used to defend and to promote the rights and interests of workers. And this recognition is also extremely important for us. I think one thing that's also important is to be clear that this opinion has also limits. It's not legally binding, and it does not define in detail how the right of strike should be exercised. The court in itself says that it doesn't determine the precise scope, conditions, or limitations of their rights, which leaves open space for governments or employers to continue pushing for new rules, possibly a protocol that could regulate and potentially restrict how strikes are carried out. I know that when we as workers go on strike, we usually discuss the strike rules with the employers before we go on strike. So the fact that there's space for governments to fight back or to push back is a concern for us when we, especially when we look at the global context. If you look at the ITUC Global Right Index, and I'm referring to last year, unfortunately, I have not read 2026, but the Global Rights Index mentioned that violations of the right of strike are widespread, affecting most countries. So for us, whilst this opinion is a step forward, the reality on the ground remains challenging for us. At this moment, you might want to ask us, so where do you go from here? We await the ILO governing body to sit, which would only be November, and then they will discuss the next steps forward. But for us as the trade union movement, one thing is clear in terms of the right to strike, that we should not only defend the recognition of the right to strike, but also ensures that it can effectively exercised in practice. So this is where we are. We know that there's still a lot to do. We know that employers and some governments will come back and fight, continue to fight against the right to strike. And of course, we need to prepare ourselves and not take a back seat, because sometimes we as workers believe that when we won and we achieve something, we need to sit back. We will have to be on our back foot all the time, because we don't know what employers and some governments will do. So, Mario, as much as we are happy with the outcome, we are very cautious in terms of how employers would respond in terms of their pushback or their comeback to continue this fight. So in brief, that's where we are, Mario, not much.
Comrade Christina, thank you. I previously mentioned that we have senior figureheads from the Department of Employment and Labor. Now, at CENTROW, we deliver a postgraduate diploma in labor law, and we deliver that postgraduate diploma in labor law in partnership with the CCMA. So before I get an email from Laurie tomorrow or even later today, I should make mention that we also have the newly appointed CCMA director as part of this particular audience. And to build on the relationship that currently exists between the CCMA and ourselves. I will now open it up for input or questions to the two panelists, and we will take the discussion from there. So if there are any person, aside from the people I've made mention of, the CCMA director, senior government officials, former ILO country director for South Africa, the general secretary of SACTU, don't feel obligated to make input, but you are most welcome to do so. So I'm opening it up for questions to the panelists or for any input on this particular topic, subject matter. Do we have any takers? Don't now feel scared because we've mentioned all of these high-profile people. And here we kick off with the Department of Employment and Labor, one of the highest profiled individuals within that particular department. Sipho, please proceed.
Thank you very much, Chair. Definitely not high profile. Well, I think as a point of departure is to express our appreciation to the Prof for the work well done, and also appreciation for the comments. The issue I want to raise, let me place it as a concern that has just been raised around the opinion being advisory, which potentially leaves some open door for challenging the status quo still. What would be the advice of the Prof in terms of either the ILO or member state pushing to close that gap, moving from advisory to legal certainty? What is it that should or could be done so that we put this matter to rest permanently? That would be the comment for now.
Tanya, can I also ask you to pose your question or comment? And if there are no other questions, we will then hand back to the panelists. I've noticed Sonwabu too, after Tanya.
Thanks very much, and good afternoon to everyone. It's really just a comment to say that the contribution South Africa made, the legal team, government, is remarkable, and we've achieved something that really is historic, taking the point that this is one victory, but that the fight must continue. But just to say we're proud of the achievement and thank everybody for their contribution.
Thank you for those words of thanks to the team who argued the matter on behalf of this African government. Sonwabu, I've noted your hand.
Oh, thank you so much. Thanks to Prof and Christina. Indeed, the historical and the path must continue. What about then the countries that have used the convention and the courts then have interpreted their domestic laws using these rights? Now, in so many cases, the courts have avoided using the scope to these rights. Now, how will this impact on legislation? I know Prof has mentioned the Article 2 and Article 8. When they talk about lawfulness and exercise of respect to the law of the land, and he uses we should read this in good faith in looking at external and internal. And how will this impact national legislation, and what key tests does the Prof anticipate will define the scope of, for an example, essential workers as mentioned? Thank you, Mario.
Halton, can I hand back to you and also to Christine to speak to those comments and also questions?
Okay, yep. Thank you for the questions. I also, you know what I have forgotten to say, just how important the Department of Employment Labour was, because it was in Thembinkosi Mkhilepi and the department and the DG that pushed for our Department of Foreign Affairs for the government to make a statement and to comment on other government statements. So, I mean, I think hats off to the Department of Employment and Labour that picked this up. The Department of Foreign Affairs hadn't, and it was driven by Thembinkosi and of course the DG and the ministers. The question of advisory opinion, the ICJ, established a very long time ago and had opinions in relation to disputes between states, and that's its normal work. And then it gives advisory opinions on various, on treaties such as this one. But its binding force is not that it's an advisory opinion of the ICJ, which would otherwise be advisory. It's Convention 37, Article 37 of the Constitution of the ILO, which says that any dispute or interpretation of a convention or a provision of the Constitution, the ILO's Constitution, must be referred to the International Court of Justice for determination. And insofar as the ILO Constitution is concerned, it's not advisory; it's binding, and it's binding because of Article 37, rather than the status of the opinion under the rules relating to the International Court of Justice. Then, insofar as domestic laws are concerned, so how the committee works is the following: governments have to report certainly on freedom of association issues. I think it's every 2 years. It might have changed since I left, and they report on their legislation. The Secretariat looks very carefully at that legislation. The committee then, members responsible for that particular convention. So you have a body of 12, I think, 18 members, I think, and there's a whole range of conventions, and members are given a particular convention to look at for a certain period of time, and they then look at the legislation and they determine whether or not it changes the legislation or the failure to change legislation, and they make observations or make requests for information. And the governments then respond, and in relation to that response, so there's a dialogue that's entered into basically between the committee and the government around domestic law. So when a government changes its domestic law, let's say on the right to strike, it will report that, and then the committee will assess it to determine whether or not under Article 3, sub-Article 2, whether it has the effect of impairing the right to strike, or in this case, the right to organize one's activities. And it's drawn a line. So, for example, it permits socio-economic protests, which is obviously protests against government, but not political protests. So you can't have a political strike against a political party, but you can go on strike against a government's socio-economic policy. So it says that if you limit socio-economic protests, all right, by staying away or having then that would impair it. But it doesn't impair it if it's purely political, against a political party or against whatever. So it's been carefully drawing a line, and on essential services as well. So very often governments then declare banned strikes in certain areas. And then it comes to the committee, and the committee says, no, that's an impairment of the right. It's too generous a definition. You must restrict it, and then that dialogue goes on for years. But governments respond. Takes time, but they do respond, and they change their laws. South African legislation, of course, was in drafting the LRA. We honed in very carefully and with what the jurisprudence was then, and it really hasn't changed to date, of the Committee of Experts and the Committee of Freedom of Association. So I'm not particularly concerned about any endeavors to change the laws here adversely. In other countries, I would imagine this decision to have the exact opposite effect. That namely, they are going to listen more carefully to the Committee of Experts and bring their laws more into line with its jurisprudence.
Thank you, Prof.
I hope I've answered your question.
Christine, do you want to add to that question?
Just want to come back on the constitution of the ILO, but before I go there, the reason why we are really concerned is when this matter was referred to the ICJ, the employers already discussed whether this opinion will be binding or not. So there's already those discussions. And that's why we, should I say, cautiously happy with the opinion, but also for us as in IndustriALL, we felt that the constitution of the ILO is a little bit, can I say, gray, particularly Article 37, in terms of whether the opinion is binding or not. And this is the discussion that we would be having when the Council of Global Unions meet to really try to interpret the Constitution in terms of the opinion. So that's what we need to do. And I really take note of what Halton is saying. I think he helps us a little bit in terms of us having to interpret that particular article of the Constitution. Thanks, Mario.
Thank you. Mpumelelo, before I invite you to comment on this, because in the chat you speak that 37.1 of the ILO Constitution presents various interpretations. I mean, I would align with Halton's interpretation. And, you know, I don't want to invite a legal interpretation discussion into it. But from what I read the Constitution to say, and I quote the relevant part of 37.1, it says, disputes shall be referred for decision to the International Court of Justice. So whatever is the subject matter of an interpretation, and if there's a dispute about the interpretation, the relevant part of 37.1 to me reads, shall be referred for decision to the International Court of Justice. That's 37.1 of the ILO Constitution. 37.2 of the ILO Constitution and the relevant parts thereof, I want to just take out, is saying, and I quote, any applicable judgment or advisory opinion of the International Court of Justice shall be binding upon any tribunal established in virtue of this paragraph, unquote. It goes on to speak about other matters. Therefore, based on what I've read from the Section 37 of the ILO Constitution, I would align myself with the interpretation of Halton. But Mpumelelo, do you want to introduce your understanding of either the various views, alternatively, of the specific provision of the ILO Constitution? I hope I'm not putting you on the spot.
Hi, Mario. I think you are kind of putting me on the spot. Hi. I was merely raising and working on the backdrop of what Mr. Ndebele has raised, and I think after Christina came in, I was sufficiently covered there, because I'm more inclined to say that it's not as, at least from my perspective, it's not as straightforward as what Halton had presented. And I think what Christina was saying is there's different views. There's a strong view, and then there's a narrow view. And I think based on what the submissions that have been made today, that I think there's a deeper application of the minds to then definitively make the conclusion. I think not at this particular point in time can I then definitively give you an answer on whether or not I'm inclined to follow Halton's view. I'm more inclined to say I like the approach as presented by Christina, insofar as taking what has been presented by Halton, looking at what 37.1 and what 37.1.2 indicates, and then perhaps then drawing a conclusion then based on that. I think, I just received the invite at 4, so I wasn't sufficiently ready for the session. As the session was going, I'm just applying my mind. So you kind of did put me in the spot there, Mario. So sorry if I've thrown the spanner in the works. Thanks.
Not at all. We welcome your input on the matter. It's not certainly listed as the position of the CC, but we fully accept that. Sipho, you want to?
Yes,
Go ahead.
yes, just a quick one. I can't remember the year now, but this is the second time the ILO has gone to the ICJ for an advisory matter. And it would be interesting to then establish the precedence that was set in terms of the first advisory as to how it was taken as binding or just advisory, because that would also be another measure of arguing how do we move forward with regards to the current one. So it's a very interesting one. Thank you.
I certainly think that would be of interest. Any other views, opinions, questions on this matter? May I ask, Comrade Christina, if you were to take this to, as IndustriALL, to the global coalition of trade unions, by asking yourself that particular question, does it not create a sense of uncertainty with the advisory opinion of the ICJ? Does it not create that sense of uncertainty within the global trade union federations?
No, Mario, it's not creating for us a sense of uncertainty, but because we know how the employers think and how they would respond, we will have to look at the Constitution and interpret it for ourselves so that we can close any loopholes that the employers might look at or find in the Constitution, because definitely they will look at the Constitution. We also need to prepare ourselves in terms of if they come and challenge this advisory opinion, how would we respond to the employees? Because we know that they're not going to sit still. Together with some of the governments, you can just imagine the US government come, although they're not paying their membership, but their voices are louder than anyone else's voice in the ILO. Definitely they would challenge this advisory opinion. And it's not only Convention 87. Now they challenge any convention that speaks to the rights of workers and would benefit workers. For example, when we were in the committee for a transformative agenda for gender in the world of work, already some of the employers and governments come and said, we should not talk about collective bargaining. Instead, we should talk about social dialogue. And we know that social dialogue, there's nothing in it. You sit around the table and the employer tells you what he thinks and what he wants to do. But at least with collective bargaining, you have some leverage. And so we're not trying to scare ourselves, but we need to be realistic and prepare ourselves for the fight ahead. You cannot go to a war knowing that there's a war and you go without ammunition to that war. So it's one of those things that we need to discuss and prepare ourselves for. But like I said, Halton has helped us in terms of the Constitution, free legal advice for us. And that's what we will also take and have a look at.
Mario, can I just come in there just to say that the ICJ was asked to determine, whether a night work convention in relation to women, and that's what the when they handed down the decision was given that effect. So historically, the ILO has always abided by the decision. I mean, I think if you look at 37.1, and your very good point in relation to subarticle 2 of section 37, being that the advisory opinion is binding on the tribunal. Well, the tribunal was the idea is the tribunal, that the governing body could establish a tribunal to deal with these disputes internally, and it hasn't established that tribunal, so that's why it's gone off to the ICJ. But the idea that the tribunal would be bound by the advisory opinion tells you exactly that it must be binding on the ILO itself. And the very important point is, it's, as you said, is too, when you pass Article 37, it says any question or dispute concerning an interpretation of the Constitution or subsequent convention, okay, refer to the ICJ for decision. So, it's very hard to think that there's much room for a legal interpretation of Section 37. Of course, we know that nevertheless one can just obstruct and create institutional obstacles to full compliance with a decision of the ICJ. But as a matter of legal interpretation, I think there's very little doubt about what Section 37 means.
And Paul Benjamin is going to say I was his student, so because my interpretation aligns with yours, it means that he's done a good job. Anyone else? No questions, no further input. Okay. We all seem to be convinced now that those who argued, the Halton Cheadles of this world, who went to argue the South African government's case before the ICJ, they did a good job, in interpreting what Convention 87 means in the context of the right to strike. We've also had input from Comrade Christina Olivier of IndustriALL, pointing to the positive the positive opinion of the ICJ, and how, as a global union federation, amongst other, they are now in a position to ensure that workers' rights are indeed protected in line with the ruling of the ICJ and how it should be interpreted. And I think personally, if one were to provide an argument, I would argue against that line of interpretation. It almost would require of you to rewrite the convention, where the wording used by the ICJ when they provided the interpretation was informed by the existing Convention 87 text. To come up with a different interpretation after the ICJ had delivered its advisory opinion, I would argue would require a rewrite or an amendment of the existing text. But that would be my view on that matter. I mean, I'm in the company of many more senior people that, you know, do legal interpretation, and yeah, my opinion would therefore then count less than theirs. Guys, I think we have now come to the end of this particular webinar. I want to first and foremost thank the conveners of the webinar, and that would be Professor Debbie Collier, who is also the director of CENTROW, Professor Paul Benjamin, who is associated with CENTROW, and the current director of Cheadle, Thompson and ISM. And then, more importantly, the two panelists that made this all possible, and also if it had not been because of them, if it had not been because of them, we would not have had the high profile kinds of attendances that we've managed to observe today. So Emeritus Professor Halton Cheadle, who took some time out from now enjoying the sunshine of the UK. Thank you for making yourself available, as has ordinarily been the case. Comrade Christina, it's been a pleasure seeing you again after, I think, a lengthy many years. Nice seeing you again, and always appreciative of your contribution to the global trade union movement, holding up the torch, if I can put it that way. I will now allow for a final word from the two panelists, and then we will close after that. Alton, you want to go first?
Okay, well, just thank you very much. And it's more than sunlight or sunshine here. It's unbelievably hot. I think it's reaching 38 degrees and very, very humid, and absolutely no breeze at all. I honestly, it's not the kind of London that I kind of expected. But thank you for the opportunity to talk to all of you and to take your questions. And Christina, very, very nice to meet you after so many years.
Thank you, Mario. Yeah, Halton, it's very hot. We're dying here. Mario, thank you so much for organizing this webinar. Indeed, the way Halton explained it, I don't think anyone can be confused in terms of Convention 87. So Halton, thank you very much for that, and thank you very much to everyone for your inputs. I think there's a lot that I can take away to our meetings that we are going to have to discuss the way forward in terms of Convention 87. And indeed, Halton, some of your legal opinions and interpretation would help us in the discussions that we have. So thank you very much again, Mario, for inviting me. I think it was a very good webinar, so thank you so much for that.